Patsy in London. Good evening.
Good evening, sir. Thanks for answering my call. Actually, I had an issue at work with my contract. I was 2P'd over to this company about 4 years ago. In January of this year, my area manager asked me if I could do an extra hour. I did agree with her and I said yes. So she said she would put that hour into my contract, but she didn't say she was going to change the contract.
Sorry, is this a one-off extra hour or every week?
A one-off extra hour.
So why would that go into your contract, Patsy?
I don't know.
Okay. What's your question anyway?
My question is, do they have the right to change my contract, my previous contract, to this new contract without my consent?
Well, what's the change in the contract?
The contract is now a new contract, which my previous contract, I'm entitled to 30 days holiday. Now I only got 20.
So is this completely separate from what you were just talking about, being asked to work 1 hour extra in a particular week, which you agreed to?
Yeah.
Right. So you're not asking me about the hour. I'm just trying to get this straight in my head.
I'm not asking about the hour. I'm asking about if they have the right to change.
Right. The change is they've reduced your holiday entitlement from 30 days to 20 days.
Correct.
Was that 30 days including bank holidays?
No.
So previously you had 30 days plus 8 days bank holiday?
Correct.
Wow, that's generous. What do you do, Patsy?
I clean in a school.
Okay. I mean, I'm surprised you get that much holiday as a cleaner, because
it's a long-time contract, which was with the local authority.
Okay.
And I worked there for 17
right.
years.
So you've got it through seniority. I understand.
Yeah.
So the new company is saying they're changing it to 20 days. Sorry, you mentioned sick pay as well. What's the sick pay aspect?
I'm not even sure, but I'm told that I'm not entitled to sick pay.
Okay. So there's two aspects to this. First of all, are they allowed to make changes generally? Second of all, if they are, is that fact changed by the fact that you said you 2P'd over 4 years ago? And for anyone who doesn't know, 2P is a law. It stands for Transfer of Undertaking Protection of Employment Regulations, which says that when your contract, cleaning contract in this case, is taken over by another organisation or subcontracted out from a local authority to private sector companies, the new employer is not allowed to change the terms and conditions for a reason relating to the transfer. So let's come to the general point first of all. They can only change your terms and conditions in two circumstances. Number one, if you agree. Number two, if they dismiss you and then re-engage you on the new terms and conditions. Have you agreed to the new terms, first of all?
No.
Okay. So if you don't agree, all they can do is dismiss you and offer you re-engagement. If they've gone through a very detailed consultation process with your union, with you, with the workforce as a whole, then and they can show there's a good solid business reason for reducing your holiday and reducing your sick pay entitlement, then they might be able to get away with it, because a tribunal will say that the dismissal and the offer of re-engagement, but the dismissal was a fair dismissal if they've got a really good business reason for imposing these changes to your terms and conditions. Tribunals don't like reductions to terms and conditions. They'll normally want to see that the directors have taken a hit to their income as well. The law's going to change in about a year to make it much harder to change terms and conditions, and I suspect that's why your company is doing it now before the law changes. But broadly, they are entitled to change those terms and conditions if and only if they've got a really good business reason and they've been through a full consultation process. It certainly doesn't sound like the latter is the case from what you've told me. Yeah. But you're in a slightly different position because you came over under 2P, under the Transfer of Undertaking Regulations. That says your terms and conditions can't be changed at all if the reason for the change is connected to the transfer. Now, if those changes had been imposed 6 months after you moved, a tribunal would have said, yeah, of course it's because of the transfer. 4 years down the line, your employer would have a decent argument at saying, well, it's not because of the transfer anymore. We honoured Patsy's terms and conditions for years. It's now because of the different, tougher trading conditions, because of the tighter margins we're operating under, because of the increased employer's national insurance, which has dented an already very, very slim profit margin. Whether a tribunal would agree with that, I can't predict, but it's a plausible sounding argument, Patsy. Here's what I think you should do. You're going to be a member of a union, I assume, cleaning at a school.
I am not, no.
Oh, you're not? Did you opt out of union membership?
I did some time ago, yeah.
Okay, that's a pity because unions are fantastic for helping at things like this. You've just got to take a decision on what you want to do here, Patsy. You can either refuse those changes, and you might find yourself given a warning that if you don't accept them, you're going to be dismissed, and then you have to gamble on winning an unfair dismissal claim. Or you just have to say, I'll take the changes, but I'm going to look for a new job.
Okay.
Okay.
Yeah, I did write to them to say that I did not agree with the changes. They did not do the proper process.
All right.
I'm still waiting for them to reply, but they haven't.
Well, when you've got their reply, give me a call back, Patsy, and let me know what they say.
I will do. Thank you so much.
All right, thank you, and good luck with that. Thank you so much for calling in.